Good morning, ladies and gentlemen. Let's go ahead and get Senate Judiciary meeting started. Ms. Ogden, if you'll call the roll.
Senator Albritton, Senator Bell, Senator Cornley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman, Senator Stutts, Senator Weaver, Senator Barfoot.
Here.
And we have a quorum.
All right, we've got a quorum. Ladies and gentlemen, as you can see, we've got a pretty full agenda. There's committee meetings at 9:30 this morning, so we're going to do our best to get as far down this as we can. The first one is a public hearing that's been called. I'll lay out some ground rules for that really quick, but today we are having the public hearing only on this. Tomorrow morning at 8:30, we have a special set agenda that would be dealing with this particular bill that's up first by Senator Stutts. When we have the public hearing, and we're going to get into that in just a second, I know there are several people who are lined up to speak. We're going to limit that to 2 minutes apiece, and I apologize for the time limitations, but that's the best that we have in this situation. Ms. Ogden's going to set a buzzer on her phone. You'll hear that. When you hear that, do your best to stop right then. You get through the sentence if you need to, but do the best to stop then. Just be cognizant of that 2 minute time. All right, first up, SB 316, Senator Stutts.
Thank you, Mr. Chairman and members of the committee. I'll be very brief as well in the interest of time. First, I want to thank the Department of Corrections for working with me on this. We've met 3 times, I guess, and have another meeting scheduled at 11 o'clock today to meet with them and discuss these issues. But we all recognize that we have issues that we need to deal with. And very briefly, I'll tell you what Bill 316 does. It increases the responsibility of the position of Prison Oversight Coordinator, and that position was created in a 2024 bill by Senator Chambliss. It grants the Prison Oversight Coordinator access to the facilities at any time. It creates a Corrections Oversight Board. It places an investigation authority with the State Bureau of Investigations, and it provides a special prosecutor for the counties where a major Department of Corrections facility is located. And so those are the 5 things in a nutshell that the bill does. And with that, I said can answer some questions later, but I won't take any more of our time since we have a public hearing and let these people that know more about it than I do speak.
Thank you, Senator Stutts. All right, we'll start the public hearing now. First up is a proponent of the bill, Dr. Bobby White. Mr. White, are you here? Hey, Mr. White, thank you. Again, recognizing that we've got limited time, 2 minutes for you, sir.
Sure. I want to say good morning to Mr. Chairman and to the committee. My name is Robert White, and I'm pastor of Montgomery City of Refuge Church. And I do a lot of work in the prison as far as ministry is concerned. I preach at different churches and at different prisons, and really enjoy the opportunity. But at the same time, I've witnessed a lot of things that I really would like to express to the committee. And I also would like to say that I think this bill really touches on a lot of the concerns that people have, specifically transparency, the accessibility of data, and the outreach that the department would have with the public. The chamber here is filled with family members and concerned citizens of people who have been incarcerated and who are incarcerated. So I really think that this bill will shed some more sunshine on the situations that we know of, and also I think it'll give the opportunity for more communication with the public. So as a pastor, I would say, and I would really encourage us to let's continue to move forward. And also I think it's positive because in light of the litigation that's taken place, I think this would show the DOJ that we are operating in good faith and really want to correct the wrongs. I would make a suggestion that at some point we address the issue of prison officers being placed on administrative leave pending investigation when there is use of deadly force resulting in the death of an inmate. I think that's something that would help because a lot of times when something happens and a person goes right back into the population, then that creates a lot of problems. And we can just take a look at the way that law enforcement is handled when they use deadly force. They're placed on administrative leave and pending a hearing or an investigation, and I think the same would be appropriate at some point.
Thank you, Dr. White, for your comments, and just got in under that 2-minute mark. So thank you for sharing.
Thank you. Thank you.
Next up is a proponent, Rachel Elledge. I'm sorry, Rachel, if I pronounced your name wrong. Good morning. Welcome to the Judiciary.
So good morning. My name's Rachel Elledge. I'm here on behalf of the things that are going on in Tutwiler. I think a lot of times people focus on what's going on in these men's prisons, but there are women. There are women that are living in these same deplorable conditions. I was sentenced to Julia Tutwiler in 2022, and I was taken out of a very violent, drug-ridden environment and put into another violent, drug-ridden environment, except for this time it was ran by the Alabama Department of Corrections. While I was there, I never was offered any kind of classes, any kind of rehabilitation. We went several weeks without toilet paper. Us being females, we went several weeks without having feminine hygiene products. At one point while I was there, I had an officer tell me that him doing what he does as far as bringing drugs into the prison, he put both his girls through college. That's more money than what we make on minimum wage out here. We need some outside oversight on these facilities besides just ADOC. We need some outside. We need help. And I'm just here to stand up for the women. Don't forget there's women down there. Thank you.
Thank you for your comments. Thank you this morning. Next up, proponent Stacy George. Mr. George, welcome to Senate Judiciary.
Thank y'all. And I may get emotional because I didn't know this day would really ever happen, but I'm thankful for every human being in this room. Back behind me and here, I'm thankful for y'all to listen. 13.5 years as a correction officer, Limestone Prison and St. Clair Prison. And there's a need to put some eyes in here that's not attached to I&I, who works with ADOC in the same building. I saw things that it's not even in the movie, The Alabama Solution. I'm actually in the movie because I thought it needed to be told, the story. Now, there's a lot of things happen in that prison, but I'll just give you a real good example. I had these cards, and I'd carry my Bible, and those folks would tell me, those supervisors said, you got about 30 minutes, sometimes 20, sometimes 5, to get these inmates de-escalated, or we're going to tune them up. And that's what they did, was tune them up. But they didn't do it in front of me, because I'd tell on them. Okay, but they did tune them up. So when I de-escalated them, I might be de-escalating over the box of food that says not for human consumption on the food we feed them, that I was the officer over. Or it might be that they didn't get their mental health medication, because a lot of them are on psychotropic medication, because we need the mental health. It's not really being treated. They all end up in prison, kind of, you know, if they don't have a family. Or it might be that they just need somebody that cares about them. And so I tried to de-escalate everybody I could, and nobody ever got tuned up at that moment after I de-escalated. But I'd go to the cell, they'd say, George, go pray for them, because that's what you do. But I know Craig McKinney got beat to death almost. And he made it out. But he still got damage. God bless y'all. This is serious. Thank you.
Thank you, Mr. George.
Chairman,
Yes, sir.
can he just, I just got one question, come on back.
That's fine. If you
What is tune up? What happened? What is tune up? I don't never-
Tune up is if they don't do right and act right for whatever reason, then they tune them up and they don't look good when they come back. That's beat them up. Yes.
Okay.
Yes, sir. That's beat them up. And any question y'all have, in the future, anytime y'all can call me anytime, I'll say anything because it's the truth. But I just went by what was in the Bible. Bible said, do right by people in prison, just like you were in there yourself. And so it was bad. But tune it up that's what that means, sir.
Thank you. Thank you, Mr. George.
Yes, sir.
All right, next up, we have a proponent, and I believe it's Tim, is it Mathis? Mr. Mathis, welcome to Senate Judiciary.
I'm Tim Mathis, and first let me thank you all for allowing us to speak at this. This is a very important bill. It means the world to us as family members who have people or have had people inside this system. I lost my son in this system in 2024. Never had an idea that a 15-year sentence was going to turn into a death sentence. Extortion is rampant. The drugs, you get phone calls that your loved one's going to be raped. They want you to send money on green dot cards, and this is not always inmates. I've been extorted by officers, and they didn't care. They would tell you who they were. They wanted $300 or whatever to protect my child or get him transferred. And let me tell you, as a parent, people say I wouldn't do it, but you will if you want to sleep, because you don't know what is going to happen and what you got to live with the next day. That was the worst phone call I ever got in my life. I talked to my son that evening about 2 hours before he was killed, and the system provides no one any type of information when that happens. I couldn't find out where his body was. I couldn't find out where his body was being taken. This was about the time that the body parts were coming up missing from the autopsies, and I was scared to death of that. I tried to call John Ham's office every day after June the 4th when I buried my child till, I don't know, I gave up probably after about 3 months because you couldn't get the man on the phone. If he makes a statement that he has not talked to any of these people or had dialogue with them, I can assure you it is not our fault. They went so far as to even tell me that if I came to the ADOC office where he's located, that I would be treated as a terrorist threat, which I didn't go because I was afraid of getting arrested. It wasn't that I was mad. I was a mad parent, but I simply wanted to talk to somebody. I told the committee when I went the first time that I was mad. I'm going to stay mad, and I'm going to be at every meeting y'all have concerning this prison system. It has got to have some kind of outside oversight. The good old boy system is alive and well in there.
Thank you, Mr. Mathis. I appreciate your comments. I know, and I apologize again. Being limited to 2 minutes is difficult, but
Yes,
thank you for coming
I
and
appreciate whatever
speaking
we
your
can
piece.
get and anything I can do.
Thank you, sir. Next up, we have a proponent, Sylvia Wright. Ms. Wright. Welcome to Senate Judiciary, Ms. Wright.
Okay, SB 316 is not just another bill. It is a plea for truth, where truth has been hidden for too many years. We lose lives every week. The drugs are rampant. The officers see that. Okay, excuse me. We have seen evidence, real evidence. You have seen the videos, the receipts of the cash app accounts, the receipts of the Venmo accounts. When our people call, it's recorded on the wall phone. When my son pled with me and said, "Mama, please help, they're going to kill me," I owed him $650. $650. I'm retired. I'm on Social Security. That's just one phone call. When you call the wardens, they act like you are part of the problem. But yet, my son is over 30 years old. He cried for help. He's still alive, thank God. For a lot of people that have to pay the extortion fees. That happened at Donaldson Correction Facility. And I called the warden on numerous occasions, and she never called me back. And I want to say that SB 316 matters because it forces the doors to open. Excuse me. It demands oversight, and it demands accountability. It demands that the truth finally be acknowledged instead of being buried for so many years. Okay, and I want to name some names.
Ms. Wright, if you could, I appreciate it. And again, I'm very thankful that you're here sharing this information with us, but just with limited time, we've
Okay.
got other speakers. Thank you so much. Next up, we have Sam Adams with Aaliyah as an opponent. Mr. Adams.
Thank you, Mr. Chairman. Members, I just wanted to point out that this is a 18-page bill, and I'm not here to speak about the first 17 and a half pages, but on the last page is where it involves Aaliyah in investigating all complaints inside of prisons. And first, this is something that would significantly expand our investigative responsibilities at Aaliyah. Based on the numbers we've received, we estimate we'd have to hire at least 60 additional special agents to handle this tremendous caseload. More importantly, this is outside of traditional free world investigations that our staff and our leadership conduct. And so it would have to, they'd have to have extensive training in order to do these investigations because they involve different case law, different statutes, different constitutional elements. And then finally, assigning these investigations to Aaliyah and to the SBI would expose our leadership and staff to additional litigation from past and future cases that go forth before the ADOC, which would be a tremendous resource allocation for those. And all these efforts would divert from our core public safety functions that we have at Aaliyah with highway patrol, driver license, and SBI, among the other many and varied responsibilities that we have. So my job here today was just to point that out and make that clear to the committee, and I appreciate your time.
Thank you, Mr. Adams. Just want to note, members, that if you just joined us, this is the public hearing only. We have a special called hearing to consider voting on this tomorrow morning at 8:30. We're not going to vote on it today. I want to tell the folks who have come up and spoken in favor of the legislation that we truly appreciate you being here. There are members on this committee, members throughout the legislative body that have heard you today, not only today, but in the past. I'll also say on the other side of the equation, the members of the legislature who have taken steps to help rectify, remedy that situation. Thankful for the governor. And in some cases, although it may not be applauded, but what DOC recognizes in some cases as a problem and the acts that we've tried to do to correct that. So, Senator Stutts, I'll turn it back over to you if you want to just have a closing statement that we're going to move through the agenda.
Thank you, Mr. Chairman, members of the committee. And I said we're meeting at 11 o'clock today to try to discuss some of these issues of implementation, but look forward to our meeting tomorrow morning. And it's a serious situation, and I understand there's expenses involved, but we've spent millions and millions of dollars of settling lawsuits with the Department of Corrections. We have others pending. The cost is not the issue. It's humane treatment, it's accountability, and it's transparency. And those are the issues that I hope to address. And thank you, Mr. Chairman.
Yes, sir. Thank you, Senator Stutts. All right, now we're moving along. HB 228, Representative Hill. Good morning, Mr. Chairman.
Mr. Chairman.
Yes, sir.
Got a relationship to this bill, right?
Yes, sir. Go right ahead.
I move favorable.
Got a motion for favorable, second by Senator Bell. Any discussion on the motion or the bill itself? What let me say this: if memory serves me correct, several weeks ago we had a pretty extensive public hearing on it. I know that was several weeks ago. Judge Hill wasn't able to be here. Glad you're back with
Yes,
us.
sir. I'm sorry. I had pneumonia for 3 weeks. I will assure you I would have far preferred to have been here than where I was. What this does, Senator, is that, the NISE law takes care, it's where bonding, the very most serious violent crimes we have. This gives the DA and the defense attorney an opportunity to or to set a bond if they can. If they cannot, then the one must be had within 10 days, and that 10 days, it can be moved to 21 days by agreement. It says that those hearings must be recorded, and that if we have a NISE law hearing, it takes the place of a preliminary hearing. They just fold it into one hearing instead of having two, so it gives you some judicial economy there. And really, that's it in a nutshell.
Mr. Chairman.
Senator.
I have to ask my friend though, that Judge, I have a concern, and the concern is simply this: is that forensics itself sometimes takes up to 6 months before they analyze and get that information back to us. If this takes place in the manner that it is, then the question I pose is, how will the defendant be able to get discovery which is provided in the preliminary hearing, which can be moved, set, extended, continued on bond until they get the information, and then they'll have an opportunity to secure it in the preliminary hearing so that they can have an opportunity to know what's against them, and of course be able to request through discovery the information that may relate to that if it's available.
I got you, Senator. That's a good question. Here's the situation, though. Excuse me. As you know, a preliminary hearing is a probable cause hearing. Discovery is not necessarily provided in full at a preliminary hearing. It is provided in full at the point in time of arraignment, which follows a grand jury indictment. And at that time, the forensics and that type of discovery would be provided. At the NISE hearing or at the preliminary hearing, the defense attorney, because it's going to be recorded, so that helps them. The defense attorney could call any police officer witnesses that he wanted to, and that individual, while they could certainly give their opinion, it would be hearsay. But again, hearsay is allowable in a preliminary hearing because it's nothing in the world but a probable cause hearing. It is not a trial de novo or a trial where you're looking at proving an individual's guilt beyond a reasonable doubt. So that's the way I would answer it, Senator. Before they were asked to be put to trial at a point in time that they were at jeopardy, the discovery that you are speaking about would in fact be made available.
But under those circumstances, some of the discovery, once it has been, just like I said, forensics. Forensics, it's in a small number, but forensics information can actually have the case dismissed.
It could.
But what if we don't get it at the preliminary hearing, then you see the problem that exists.
I do, Senator.
It's a problem. It really is a problem that this person is going to be moved from that point to the grand jury, and it's no opportunity once again to secure that information. I hear what you say about the standard at the preliminary hearing.
Yes, sir.
But
I know you know that, Senator. You've had them just like I have.
But at that phase, not many, but that case can be dismissed after the actual hearing if you be able to present what that information is that they're being held accountable for.
But if the district court judge at a preliminary hearing finds that there is no probable cause to take this case forward, that does not preclude the district attorney from presenting it to a grand jury.
That's true.
They can do so anyway.
That's true, but the defendant, they don't have the information though. That's the problem. Even if they move, you know, I can just all I'm gonna say that I'm in the middle.
I
I'm in the
understand
middle
your
of
question,
something
Senator. Put a couple $100 million more in forensics, and maybe we can get it quicker.
Well, we did the best we could. We built a whole new center in Hoover.
I know that.
You know, so we did what you just asked us to. But Judge, that's I have some serious concern about the inability for discovery to be had by the defendant until they've already been indicted by the grand jury. Their trial has been set, and now we want to present this information. And that in itself, that time phrase in some of these circuits, I don't think grand juries meet every month in every circuit.
They do not.
And so we're talking about months, the evidence that could be secured here. Now witnesses and evidence is 3 or 4 months down the road before you get to that point. And so I see a problem for defendants.
Senator, I've got a potential fix, maybe a bomb but let's the two of us talk, and
Okay.
Judge would certainly appreciate your conversation in that
Yes, sir.
offline.
Okay.
So I understand your concerns.
Okay.
Only thing I can tell you, Senator, is honestly, after people have been convicted, I have had defense lawyers come in with DNA, and you know, we're doing so much better with DNA than we did 30 years ago when I went on the bench. And I've allowed them to reopen the trial, present that DNA evidence, or had it tested with that understanding that if it came back that individual was impossible, then I told them I'd dismiss the case. So I don't know, Senator. I trust our judges to do. I like judicial discretion, and I think we ought to trust our judges to do the right thing.
Judge,
Well,
I've always liked judicial discretion too, as long as the discretion's on my side of the equation.
That's what we talk about now. I was getting ready to say the same thing you said. It's just that I think that, and I want to say this just only because of the statement you made, Judge. I think I would say that at least 90% of you all, in here, know how I believe that judges ought to have discretion. I've studied that every day in here, so it's not trusting judges. I trust them probably more than most folks because I know that they're going to do a good job. But the problem is, and I'm through, so we can move on. The problem is what I just said. See, I'm not going to repeat it again. That's the problem there on the front end. Is that yes, I think the judge is right when they hear it and deny them getting the bond because of Niles' law. But that's just dealing with the bond. The preliminary wasn't set up just to deal with bond. In fact, I'm not telling the judge anything, but actually bond hearings are usually set before the preliminary.
Yes, sir.
And so the fact that a Niles' law is focused on whether the bond or not, I agree with that. I supported that, and I support the revision. We're trying to do some revision. But we are taking away a constitutional right of somebody to get this information, to be able to prepare for their accuser. Because if we have a preliminary hearing, you can't prepare if you don't have the stuff.
The only answer I got for you, Senator, is you get it prior to the point in time that you are put to trial and the real case comes to issue. And look, we're saying the same thing. I got you. I understand.
All right, we've got a first by Senator Smitherman.
Yeah.
And a second by Senator Bell. Any further discussion on HB 228? Hearing none. Ogden, if you'll call the roll.
Senator Albritton, Senator Bell, Senator Cornley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman,
I would further work to be done.
Senator Stutts, Senator Weaver, Senator Barfoot.
Aye.
Ms. Favorable.
All right, Mr. Chairman, favorable
Thank you, sir.
report.
And
Thank you.
Senator Smitherman, I wanted to compliment you on the beautiful color of your shirt.
Well, I had, the only thing I did was, I got the memo. That's what I'm telling you. I got the memo. Thank you, Judge.
All right, up next, SB 318, Senator Coleman. Senator Coleman, I understand that you have an amendment that one of the committee members is going to be offering. Senator Coleman Madison, just if you will, tell us a little bit about your bill, and then we'll let Senator Coleman Madison offer her amendment.
Thank you so much, Mr. Chair. Ooh, that's loud. About 6 years ago, I had a group of survivors of child sex assault to come to my office when I served in the House and just tell me all of these stories. And from that point forward, I became a champion of trying to, on the civil side, to help give them some recourse. So we've had several bills in here prior to on that. This bill actually on the criminal side adds to the definition of crime of sexual torture. Again, heard some stories about, it's a very adult topic, and I know that people watched, even young people watch this stream, but it does extend the crime of sexual torture to include penetration also of the penal opening, which for whatever reason, we didn't have that in our definition before. And so, Mr. Chair, I know that a member has the amendment, and before we leave, I just would like to introduce, I want to have permission to introduce someone
Sure.
as well.
Senator Coleman Madison, you've got an amendment you'd like to offer? Members, you've got
Microphone.
a first by Senator Alford. I'll make a motion. Senator Orr first, Senator Smitherman's the second on that amendment. And just any opposition using previous roll on the amendment? Hearing none. All right, now back on the bill as amended. Do have a motion? First and a second. Members, any opposition to giving bill a favorable report using previous roll? Hearing none, so ordered. Senator Coleman, you had somebody you wanted to.
Yes, thank you all so much to the members of the committee. In the audience today is actor Gil Gay. I wanted to introduce him. I know he had been going around and meeting with some of you all. People all around this country have been paying attention to what Alabama is doing as it relates to survivors of child sex assault. And Mr. Gill is one of those folks that's been following us and trying to get some other things passed here in the state of Alabama as well. And I just wanted to thank him for coming to the state of Alabama. Thank you for what you're doing for children all around this country. He has a great, do you say filmography? Is that how you say it? Sure. All of my favorite stuff, CSI, Deadpool, NYPD Blue, all of these other things, but he's using his time and his platform to fight for children in this country. So wanted him to, and maybe we can give him a round of applause too and thank him for coming to the state of Alabama. Thank you.
Thank you, Senator Coleman.
Thank you.
Next up, in the bill is given favorable report as amended. SB 260, Senator Melson. Senator Melson, we don't get the privilege of having you in here many times that often, but welcome.
Thank you, sir. I think this bill has been taught to you by the lobbyist who's wanting this bill to pass. It's about storage units, and it's trying. No, some of them want to kill. This bill has to do with storage units and trying to get it into the 21st century a little bit, using the internet to communicate people. I know that we have a storage unit, and we frequently pay our bills, get notices, and everything online. I think the concern has been about taking the newspaper requirement out, but I know most people don't even get the newspaper, or they get it. Very little look at that section. You know, now the notifications are so diminished that I never even look at them, and so this just does that. It addresses some other things in the bill. I do think there's an amendment Senator Figures would like to offer.
You want to offer? You've got an amendment.
I have an amendment to offer.
This is in the package already, I believe. Senator Figures, if you would just briefly, to the best of your ability, explain what the amendment does.
The first part of it says replace line 13 through 14 on page 1 with the following: after the lease has been delivered by first-class mail or electronic means for at least 30 days. In the instance where an occupant uses a unit after the agreement has been either mailed to them or emailed to them for at least 30 days and they don't execute it and return it, but continue to use the unit, the agreement would become effective if the occupant has executed it. On the next part of the amendment, replace line 48 on page 42 with the following. Such newspaper does not exist or the property is valued at $500 or less. This language is the current law that was left out of the synopsis. And let me go back and say the reason for all of these amendments is that the wrong draft of the bill was filed initially, so they're having to go back and make these corrections.
Does this line up with what the House version? I think there's a House version. Am I correct in that?
It does.
Senator
Okay.
Melson will have to, yes, once we do this amendment, it would line up with the
Okay.
House. And then replace line 182 on page 7 with the following: by first-class mail or electronic means. This language allows the rental agreement to be delivered by first-class mail or electronic means. The next one is replace line 184 through 185 on page 7 with the following: agreement that the operator has delivered to the occupant by first-class mail or electronic means within 30 calendar days. This language is the operative language in the bill that addresses the omission in the synopsis at line 13 on page 1 regarding the occupant uses the lease for 30 days but not executing the agreement. And the last part, replace lines 269 through 270 on page 10 with the following: if the personal property, and we've deleted out subject to the operator's lien, so it reads, if the personal property is a vehicle, watercraft, or trailer, and this language removes the operator liens language for the purposes of disposing of vehicles, watercraft, or trailers. And with that, Mr. Chairman, I'd like to move adoption of the amendment.
Got a motion for adoption, Senator Smitherman.
I mean, I'll second it, but I want to be recognized.
Second, and then you're recognized.
I think this is my personal feeling. I think this bill needs some I'm going to support to get it out, but it needs some serious work. I mean, that's a lot of changes right there. And the application of them, ain't no way I'm going to be able to, settle in on it. And I'm sitting in here in 3 minutes, I hear that, and then now I'm finna vote on it, and I'm selling in on what's being said. That's a lot of changes. For instance, I'm going to be short because we got a lot, but just like about the rental agreement. Okay, you rent a house, you ain't bound by no contract for the rest of the time. It's a month-to-month lease. And so you in that month, you pay for that month. And now we're saying that, if you don't sign no paper, you don't nothing, but you go use it, you locked in for the year. That's significant change in law and property. That's significant. And so it's a lot of, I see a lot of work that's got to be done on this, for it to be addressed. So as I said earlier, I'm going to support the bill, but I'm just making a serious notice, and I'm just saying it like this, Mr. Chairman. Whoever it is, you need to. I'm not trying to be special. So if anybody else on this board, on our committee has a concern, you need to get with us. I don't want to hear the bill hit the floor where you had a chance to get with us. We deal every day with 30, 40, 50 bills. I ain't running around chasing somebody because I got a concern with this bill. You supposed to chase us. You supposed to come to our offices and talk to us and make appointments. And not just on this bill. I'm just saying that because I'm just myself personally tired of hearing folks tell me you got a chance. I ain't got a chance to do nothing because I'm up here working like heck on the floor all today, yesterday, and tomorrow.
Thank you.
When I'm going to be running folks down.
Point made. You're exactly right, and I think all the committee members would agree with that synopsis on this bill or anything else.
Okay.
Senator Singleton.
Yes. One of the problems I have with the notice requirement where it says first-class mail or electronic, well, first-class mail costs money. I'm afraid that they're never going to use that. If you talk about using electronic in some of these rural areas, it can hit your junk mail, it can hit anywhere else, and people might not even see that notice. And I'm not certain that how reliable it is just sending it electronic when somebody tell me a lot of times I emailed you, but then I look at my junk mail or spam mail, there it is. Yeah. And I didn't see it directly in my mail, and it could have been 30 days, and now I'm locked into something. I have a problem with that or in that.
I understand that point, Senator Coleman Madison.
Thank you, sir. Along those same lines, and my question was, what's the verification? You can get junk mail and oftentimes you'll sign something, but what verification does the person have that you got it? There should be a check or something. Even online, you can sign a document online, but again, if it goes in your junk mail, it may stay there for 30 days. Okay, it's expired, but like both senators have said, you are locked into something that you may or may not have gotten. And again, how does the other people on the other side know that you actually got it? What's the verification?
Mr. Chairman.
Yes, sir.
The
Mr. Bell, you want to address that briefly
Absolutely.
if you can?
Absolutely, and thank you. So when it's done by electronic mail, there's a presumption that it's delivered unless there is a message that gets returned that says that this wasn't delivered or the email address was not adequate or correct.
Okay, but hold that point. Let's go back to Senator Singleton's point. It could go in junk mail or spam. I have to check archives right now. I have to check junk right now. And quite frankly, because I get so much mail in that, especially junk, I just take a quick scan and delete. Now, yes, something, and same way with archives, because a lot of things, important things may go in there, but I'll take time to check it. But this is a legally binding document. You want to make sure, you said we assume that they got it. I think you want to make the assumption on the side that you want to be sure that they checked it, that they verified, that there's some way you can verify that they got it. And there's at least a check off or something to ensure that said, okay, well, if you check this box, that means that committed you. It's okay to use electronic, but you don't know whether that person actually checked off on that. And, you know, an agreement, a contract is a two-sided thing.
Yes, ma'am, and if I may, some of these operators use kiosks and they have other ways of remote ways for you to enter into an agreement. And what we're saying is if you move into a unit and you're using it for 30 days, you know you have occupied it for 30 days and had use of it, and you refuse to come in, then you're binding yourself for continued use of it, and that's what that section does.
Members, let's go ahead and we got a first and a second on the amendment. Any opposition using previous role on the First Amendment? All right, hearing none, the First Amendment is adopted. Senator Melson, I understand there's a Second Amendment. I don't know who would be offering that. If you don't mind, if nobody, okay, we're going to move on then. So the bill as amended, you got a first by Senator Orr, a second by Senator Elliott. Ms. Ogden, if you'll call the roll.
Senator Albritton, Senator Bell, Senator Cornley, Senator Coleman Madison,
I'm going to abstain. I'd like to see what verifications they have on this.
Senator Elliott, Senator Figures,
Aye.
Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman,
I would understand this bill needs serious work.
Senator Stutts, Senator Weaver, Senator Barfoot.
No.
10-1.
All right, bill's given favorable report. Thank you, Senator Melson. I just urge you to have further communications with the
We will.
folks on here.
Mr. Chairman, can I say one thing?
If you'll make it brief.
I will. I think responsible individuals, when they buy a car, when they rent something, when they purchase anything, they know when they get in a contract and they know that their payments are due. I think we have to think about that people need to be responsible, also respect the owner, business people's rights to get what they enter in a contract as well as the others. So I'm just saying, I will get with everybody. We'll work on it. But
I agree.
Sir, can I add just one
Right.
last comment? Do they not, they have to come in to the facility.
they can do it online as well. They can enter into a contract online as well.
But when you come in to load up, there should be something there for somebody to sign off. They come to the facility. You're right. I'm not for people getting out of things, but again, physically being present, they have to come to the facility to unload. Why not have them sign it then?
Senator
They
Melson,
may do it. They may do it after hours, but I'll get by and talk to you.
thank you. I
Thank you.
appreciate that. All right, next up is HB 132. Representative Estes is a very simple bill. You can just give us a 30-second synopsis.
Yes, sir, I will, Mr. Chairman. Appreciate your time. Yes, a brief summary of this is we have been adding classifications of persons in our state to existing code for the last several years to protect them from serious bodily injury. We've had law enforcement officers, health officers or health workers, child care professionals, and others. And all we're doing now here is adding a child. I had an incident in my county or in my district earlier last year where a student got in a conflict with the other one, beat the tar out of him pretty good. The guy who's got whooped up on, his daddy come in to see the principal. And when he got checked in through security, unfortunately, the boy that won the fight walked out of the bathroom and the dad jumped him. And it took 4 people to pull him off. And so all we're doing is adding children to this. And we added an amendment in committee to clarify we're not trying to get involved with boys having a fight in school or at the locker room or whatever. That's for the principal and the superintendent of the school board necessary to handle that. So you'll see we added the amendment on the last page that says you have to be 19 or older and have no other reason to be on campus.
Thank you, Representative Estes. I'll make a motion for favorable, a second by Senator Orr. Any discussion on that? If not, Ms. Ogden, if you'll call long roll.
Senator Albritton, Senator Bell, Senator Cornley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman, Senator Stutts, Senator Weaver, Senator Barfoot.
Aye. Representative Estes, the bill is given favorable report. You'll continue, you and your family with your grandson, continue to be in our prayers. Thank you.
Appreciate that very much. Thank you very much, Waddy.
All right, next up, HB 347. Representative Harrison, welcome back to Senate Judiciary.
Well, thank you. I think this is my first time here.
Well, I thought last year you were in here, so.
Anyway, HB, I'll try to be quick.
Yes, sir.
HB 347 closes an unintended immunity loophole for developers and providers of artificial intelligence and other technologies that are designed, marketed, and configured to generate illegal sexualized imagery while preserving the core protection for a neutral general purpose tool. In a nutshell, this bill does 2 things. All right. First, it holds the platforms liable if they're not neutral. If they go in and promote this stuff and give tutorials on how to do it, then they're liable. The second, that it provides a private cause of action. And so those are the main 2 items of this bill. We did put in a thing for a removal section where they can appeal to remove the material from the internet. And I met with Meta and vetted it with them, and their only requirement was that they suggested that I put in a section that gets information from those that are harmed, where they can locate the material and take it down. And I thought that was reasonable. We added that in committee over in the House.
Got a first by Senator Bell, second by Senator Orr. I will notice 104 to nothing, which is somewhat of an anomaly. The other vote must have been absent off the floor. So any further discussion on the bill? Hearing none, any opposition using previous roll? And Senator Coleman Madison like to be added. The bill's given favorable report.
Thank you, sir. Thank you, member.
All right, next up, we've got Representative Bracey, HB 405. Okay.
Yeah. Thank you, Mr. Chairman. I told Representative Bracey I would step in for him. He had to get back to the floor.
I'll tell you, we've got a first by Senator Gavan and a second and a third, Elliott. Any members want to talk about the bill? Y'all have read it. You know what it is. It's a great bill. Any opposition using previous roll? All right. Your bill, Representative Bracey's bill, is given favorable report.
Thank you.
Thank you. Next up, HB 86, Representative England. Well, how about this? Motion by favorable Senator Gavan, and second by me and half the other committee. Members, do you want? Okay.
No, we don't need no discussion.
Well, I'll say this: I like to hear lawyers talk, but hearing no opposition. Hearing no opposition, Representative England, if you're ready for us to vote, looks like you.
Let's do it.
Any opposition using previous rule? Hearing none, bills give favorable report. Senator Coleman Madison.
Thank you. I just, Representative England just had one question. In looking at determinations, you all did not consider the inmate's health condition of them being, you have a lot of people that are just there. Monday night, there was a documentary on our prison system. And they, at one point, they showed this is the inmate prison hospital. And that was just people that were there. Many of them did not even know that they were there, you know, in their state of mind. But these are taxpayer dollars that we are paying 100%. Whereas many of them could be home with their families. And a couple of weeks after the documentary was filmed, one of the inmates expired. But the point in case, these folks are not going to be going anywhere. And so for us to just continue to maintain and keep them on the roll, I know that we sometimes have the attitude of lock them up forever. But we are paying for that. Taxpayer dollars are paying for that. So I was just wondering that you not consider that. And I'm supporting you, Bill.
Oh, no,
Just a question about it.
just for the purposes of what's considered when you apply or an applicant for parole, I felt like the reason why I didn't consider that is because what you do in terms of like getting a certification or working is something that you affirmatively do to indicate that you're ready to be paroled versus something that health-wise it's not something that you control. So for me, the parole part of that was whatever you're doing affirmatively to get parole versus how you end up by default. So that's why.
Senator Albritton.
Thank you. Look at page 2, line 53. There's some of the considerations you've added. Here it says consideration of the inmate's low risk to reoffend. Could we remove the word low and just consider his risk to reoffend?
Sure,
I
but
think that may be the meaning and the concept is still there. I think that's any risk that he has, whether it be low or high.
Gentlemen, I think that's a good discussion for later. And
if we can consider getting that done before we get it to the floor, that'd be fine.
y'all work together to see what you can come up with and see where that puts the bill, either helps it or hurts it, because it could do either one. All right? Thank you. We've already passed that, didn't we? Okay. All right. Thank you for being here.
Thank you.
Always good to see you.
Always good to be seen and viewed.
HB 263, Representative Robbins. I didn't see you out there. Glad to see you this morning.
Thank you, Chairman. Thank you, Committee. I'll be very brief. Basically, what this bill is for apps that collect and store biological and neural data, medical grade data. They have to follow the same rules as HIPAA. So it's HIPAA for commercial apps that store data.
I got a motion for favor by Senator Gavan, second by Senator Orr. Any discussion on the bill? Hearing none. Ms. Ogden, any opposition to using previous role? Hearing none, bill's given favor report.
Thank you, Chairman. Thank you, Committee.
Yes, sir. Next up, HB 302. Senator Sessions.
Thank you, Mr. Chairman, Committee. This is a bill by Representative Brown. I agree to handle it for him up here. Don't know a whole lot about it, so I have the representative from the bail bondsman to explain exactly what they're trying to do. And I know there's one amendment, and perhaps may have another one for the floor.
Yeah, and committee members, you'll notice in your package there are two amendments. I don't know who's offering.
I got one.
Senator Orr.
Longer one.
Longer one in your packet. Is that labeled as amendment number 1? I believe amendment number 1. Senator Orr's offering that. I'll second that.
What does it do?
Senator Orr.
It does three things. It tightens the qualification standard. It's from the Circuit Clerks Association. It tightens the qualification standards by adding unpaid fees as a disqualifier, along with forfeitures. It creates a consistent 30-day grace period before fees trigger reporting or disqualification, and gives the presiding circuit judge more oversight by looping them into the process.
Well, does it affect the discretion that the judge has in that situation? Is it mandatory stuff we putting in here? And
No.
the judge just as a functionary process, or does the judge have discretion based on the facts that's presented to them in this situation?
It's my understanding that it doesn't touch the judicial discretion or any of the judges.
It's just making sure they get notice and are looped into the process of what's going on in the clerk's office with bail bondsmen.
But there was three things that you said, Senator. What was the other one? I just asked about one and didn't understand the other.
Tighten the qualification standards by adding unpaid fees. If the bail bondsmen didn't pay their fees, then that could be a disqualifier, along with
What fee we?
to be a bail bondsman.
I think I could explain it a little bit better.
All right.
Go right ahead.
Oh, come on now.
Identify yourself to the committee if you could.
Chris McNeil with the Bail Bond Association. Alabama is the only bail state that does not have a reporting hub. So what this would do is when the bail bond companies recertify with the courts every year, for those bonding companies that do not qualify and owe fees or owe forfeitures, that would be sent to the state board. And then the state board could disseminate that information through the different clerks, because we don't want a bail bond company shut down in one jurisdiction because they did not handle their responsibilities and go and open up another jurisdiction. That's what it's gonna clean that up.
Okay.
We've got a motion for a first and a second. Any opposition using previous roll on that amendment? Hearing none, the amendment's adopted. Members, you'll notice there's a second amendment in your package. That's an amendment that we're not going to consider today.
We'll have to clean that up.
Look at that because I don't think it fits. Now we're back on the bill as amended. Motion for favorable by Senator Elliott. Second by Senator Coleman Madison. Any opposition using previous roll? Hearing none, the bill is amended is given a favorable report.
Thank you, Mr. Chairman. Thank you,
question.
committee.
I have a question though.
Sure.
Before we go.
We got one more bill, but
Wasn't it-
yes, sir.
Wasn't this the amendment that we just passed another amendment?
No, sir.
Oh, okay.
No.
Okay.
That amendment did not fit.
Okay.
All right. Lastly, ladies and gentlemen, I'm gonna talk about really briefly my SB 336 is last on the agenda. We will not take a vote on that today. This is some people refer to as actually the act is the Paris Hilton Child Safety and Accountability Act. The intent of this bill is to provide extra safety and security for those children who are in DHR homes or in DHR facilities that are monitored by DHR. You'll hear some things over the next week or so more about this bill. I'm asking you simply because I know we've got a committee hearing, another one we've got to get to. I'm asking you to look through this bill, realize that it does add some protection for children in the state of Alabama, which I know we all care about. So look at this bill and examine it, and then let's talk some more. Meeting is adjourned. See you next week. Or see you tomorrow for a special called hearing.
Is this gonna be, I'm gonna ask a question before they get out of here. Do we need to make a motion and say that's gonna be a breakfast meeting? You know?
I move it's a breakfast meeting, and you're in charge of bringing the breakfast. All in favor, say aye.
Hey, well, I'm getting ready to write I'm getting ready to write a request from the committee to pay for it.